Welcome to our GDPR training for AdTech and MarTech companies. My name is Michal and I'm a content marketer here at clearcode. This presentation is broken up into two parts. In the first part, I will walk you through the fundamental changes that the GDPR introduces to the online advertising and marketing industries, and then I'll talk about the key terms of the GDPR. The second part of the webinar, which will be led by my colleague Michael, will focus on the main technical and legal challenges that the companies in the online advertising and marketing industries face. Michael will also discuss the tools that companies can use to manage user consent and talk about what the GDPR means for the future of AdTech and MarTech. Before we start, I just wanted to introduce clearcode and tell you a bit about our experience within the online advertising and marketing industries. clearcode is a full-service software development house specializing in building custom advertising and marketing technology platforms for vendors and agencies. clearcode also helps AdTech and MarTech vendors comply with the EU's General Data Protection Regulation and e-privacy. Puic Pro, our subsidiary company, is a GDPR-compliant analytics and marketing suite that consists of an analytics platform, tag manager, customer data platform, personalization, and GDPR consent manager. By building the technology, as well as offering a product in this space, we have this unique position to see GDPR from different angles. So first things first, what is the GDPR? The General Data Protection Regulation is a regulation spearheaded by the three European Union institutions: the European Parliament, European Commission, and the Council of the European Union. Its goal is to give data subjects control of their data and make the regulatory environment simpler for international business. GDPR replaced the Data Protection Directive on May 25, 2018. What's interesting is that your business doesn't have to be based in the European Union to be affected by the GDPR. For example, if the business collects, stores or uses data from data subjects in the EU or EEA, then it will have to comply with the GDPR. For example, a US-based AdTech company that collects cookies from users in the UK would still be bound by the rules of the GDPR. Alongside the GDPR, there is also the e-privacy directive, which is another piece of EU legislation that also aims to protect the data and privacy of EU and EEA citizens and residents, but with a stronger focus on respecting their private lives when using electronic communications. The e-privacy directive came into force in 2002, which resulted in cookie banners displayed on EU-based websites informing users about the use of cookies on the website. However, since the GDPR came into force, these cookie bars have been replaced by consent forms. We'll talk about them later. So, as I've mentioned, e-privacy is still a directive in the process of being transformed into regulation. And when introduced, it will repeal the current directive and complement the GDPR. It is not known exactly when the e-privacy regulation will come into force. The proposal is set to be negotiated in a trialogue between the three EU legislative institutions, the European Parliament, European Council and the European Commission. And because of the delays in the negotiations, it is unlikely the legislation will be implemented before 2020. So, what's the difference between GDPR and e-privacy? Both the GDPR and e-privacy are based on articles of the EU Charter of Fundamental Rights. The GDPR is based on Article 8 and relates to the protection of personal data. Specifically, it reads, "Everyone has the right to respect for his private and family life, his home and his correspondence." Whereas e-privacy is based on Article 7 and relates to respect for private life. The article specifically reads, "Everyone has the right to respect for his or her private and family life, home and communications." This basically means that the GDPR is focused on the protection and handling of personal data, whereas e-privacy more specifically deals with confidentiality of electronic communications. Also, e-privacy is lex specialis of the GDPR, meaning that when the two regulations cover the same situation, e-privacy will override the GDPR. The fines for breaching e-privacy regulation are the same as in the case of the GDPR. GDPR and e-privacy differ in specific areas, and chances are that advertisers and marketers will have to pay closer attention to e-privacy, as it will be more detailed, of course once the draft is finalized. Within the GDPR there are a number of key terms that appear quite frequently. I'd like to highlight them now and talk about a couple of key changes that the GDPR brings. First, data subjects. Data subjects are online users that we collect data about, that come to our websites, are our visitors, clients or prospects. A data controller would be the website that these data subjects visit or an application that they use. So these are generally brands or advertisers, as well as publishers. The third term, data processor, is the company that owns the technology and collects the data about the visitor, but on behalf of the data controller. So in this case, all marketing and advertising technology vendors are classified as data processors. The only exception here would be a company like Facebook, which would be both the data controller and data processor, because they both track user behavior and process the data for advertising purposes. When talking about the GDPR, we need to discuss the legal aspects of data processing. But what does it mean exactly? The GDPR states that there are 6 different ways in which processing of personal data is lawful. I will briefly go through them now. First on the list is consent, something that almost all advertising and marketing companies will rely on. As a general rule, if your data collecting, storing or processing activities don't fall under one of the below purposes, then you'll typically need to obtain consent. There are of course many different layers to this, but we'll talk about this in a bit later in the second part of the presentation. The second case is reserved for situations where we do not need to collect explicit consent, as the processing is a result of contractual obligations. For example, if a user comes to your e-commerce store and they order certain products from you, then you have to collect their address in order to send them the product or for billing purposes. In this case, if you collect the address for the purpose of fulfilling the order, then it's a contractual obligation and you don't have to obtain explicit consent for that. It's different if you then wanted to use the data for other purposes, such as running ads on the site, then you'd have to collect consent from the user for the purpose. Vital interests applies in cases of emergency, for example when there is a need to locate a person to save their life, or there is a humanitarian disaster, or for the purposes of fraud prevention. In these cases, collecting user consent is not needed. Public interest is also similar to the previous 2 purposes. So for example, if there is an epidemic and it's required to process the personal data for some reason, for example to monitor the epidemic, how it spreads for example, it can be processed under the public interest clause. The last and probably the most controversial one is legitimate interest. There is a lot of confusion about it, specifically about what it is and whether AdTech and MarTech companies can rely on it as a legal basis for data processing. The main challenge for AdTech and MarTech companies is to actually prove that there is legitimate interest to collect and use personal data. You cannot simply say that you have legitimate interest to collect data because your business model involves displaying ads, as many companies are claiming. An example of legitimate interest in the context of advertising and marketing would be if you have a live chat tool on your website and the user types in their email address to be contacted once an agent is available. You can use this piece of personal data without consent to contact the user to answer the inquiry or resolve an issue. So now that we have a better hold of the GDPR, let's take a closer look at the 4 main areas that will impact AdTech and MarTech companies. While the GDPR will affect AdTech and MarTech companies in many different ways, these 4 main areas will certainly have the biggest impact. Personal data is the first area, which the GDPR defines as a piece of information which either separately or combined with other pieces of data can be used to identify a person. Identity in the GDPR sense doesn't necessarily mean knowing a person's name. Instead, it's about confirming that it's the same person who, for example, visited the website a couple of days ago. User consent and user rights. In a post-GDPR world, companies operating in the online advertising and marketing industries need to be completely upfront with online users about what they plan to do with their data, with whom they wish to share it, and how long they will keep it for. At the same time, they need a clear consent for the collection of data. Next, data breaches. A data breach essentially means that a data subject's personal data has been accessed, transferred, or used by someone who wasn't authorized to do so. Next, data protection by design and default. So what does it mean? Companies should put data protection and user privacy at the forefront of all their activities, from collecting user data to designing and building new software. By default means that settings, for example in consent boxes, should be set to favor privacy. We will now discuss these 4 areas in more detail. Up until GDPR, most AdTech and MarTech vendors operated based on the fact that they were not collecting or dealing with personal data. The reason for this is because online identifiers such as cookie IDs, IP addresses, device advertising IDs, and device fingerprints were not considered examples of personal data. However, under the GDPR and e-privacy, essentially any piece of data or information that can be in some way used to identify a person is classified as personal data. So for example, if your web analytics software is able to identify returning visitors, then you are collecting personal data because you are able to identify that the user visited the website previously. The same applies to retargeting and frequency capping. So, what is the meaning of this for AdTech and MarTech companies? Well, as most online advertisers, marketers and publishers collect and use online identifiers such as those mentioned above, as well as location data, they now have to take additional steps to ensure that they are compliant with the GDPR's rules regarding the collection, storage and usage of personal data. The GDPR states that companies collecting personal data should implement measures to ensure the data is protected at all times via encryption and pseudonymization, for instance. However, most companies already do this for personal data such as emails, phone numbers and IP addresses, but they do not have to apply this to all types of data they collect. The GDPR also lists different types of personal data. Let's have a look at what the difference is between personal, anonymous and pseudonymous data in the context of web analytics. An example of personal data could be an IP address. When used on its own or combined with other pieces of data such as cookie IDs, it can allow us to identify a user and create a user profile. We use the data to track their behavior on our website, such as which URLs the user has visited, or other behavioral or non-behavioral information about the users. Next, anonymous data. Put simply, anonymous data is the kind of data that can be used to identify an individual. This doesn't only apply to knowing their name or email address, but also to identifying if they are a returning visitor. So, for example, if we wanted to run anonymous web analytics, we would have to ensure that the user was anonymous when they visited our site for the first time. So, we cannot collect any personal data about them or use any previously collected personal data. The example here shows the type of data that will be available if you use anonymous web analytics. In this case, it's aggregated number of times a particular URL was viewed. So if your company claims to only collect anonymous data, then that means that you won't be able to display metrics such as unique visitors or returning visitors, or in fact run any kind of ad retargeting, because this would mean that you can in fact identify users. Pseudonymous data is something slightly different. In this case, we use a user's email address or IP address and then assign a hash to it, using an MD5 sum or another hashing function. In this case, we can still identify the user via the hash when they come back to the website, but it's not possible to reverse the process to view their personal data, such as the email address or IP address. So having the database does not allow us to identify the user. It would also work with a two-way hashing or a two-way encryption function. If we stored the data separately in different databases, this would also count as pseudonymous data. Pseudonymous data has a small advantage because in the case of a data breach, we are not obliged to inform all data subjects about a possible leak within 72 hours, and we would have to do this if we didn't pseudonymize or encrypt the data. That is, as long as this data cannot be reverse engineered to reveal any kind of personal data. By pseudonymizing or encrypting personal data, companies can limit their exposure to the GDPR. However, we still need to treat it as personal data and have lawful basis for collecting and processing it. Next up is user consent and user rights. What is the impact on AdTech and MarTech companies here? All companies that have a website, from brands to publishers, not only have to implement a user consent pop-up to gain voluntary consent from online users, but they also have to store and manage these consent requests, which, depending on the size of the company, could come in thousands or millions. In addition, companies have to implement technological changes that identify users and their consent decisions, and then take the appropriate actions based on them. For example, fire tags to pass data to certain platforms and tools, of course based on the purposes outlined in the consent request, or refrain from firing tags. Also, AdTech vendors have to tell users the current status of the activities they've consented to and allow them to exercise their rights. Next, they have to set the data to expire within a certain time frame, for example 6 months from the time the user accepts the request, and pass the user's consent decision to all parties involved in the consent request. For example, if the publisher asks a user if they, their AdTech partner and the AdTech partner's client can use the data for advertising, then the user's decision will need to be sent to all these parties. This is particularly challenging in online advertising, as for any given ad request, a user's information could be accessed by dozens of third parties. And finally, AdTech and MarTech companies should possibly respect the user's privacy settings configured in the browser, if and when this type of option is made available by the browser vendor. Under the GDPR, data subjects have specific rights which the companies processing data must respect. The first is the right to be informed about the existence of profiling, its consequences and purposes. Next, the right of access, which involves confirmation that the site is processing individual personal data and allowing users to access the data being processed, also providing them with additional relevant information regarding such processing. This right was already a part of the Data Protection Directive. Next is the right to rectification of inaccurate personal data concerning the user. Taking into account the purposes of the processing, the data subject shall have the right to have incomplete personal data completed, including by means of providing a supplementary statement. Next is the right to erasure, which means that upon request, the personal data about the user must be erased without undue delay. This is also known as the right to be forgotten. Next, the right to restrict processing. If the accuracy of the personal data is contested by the data subject, the processing is unlawful, or the controller no longer needs the personal data for the purposes of the processing. Next, the right to data portability, meaning that the users have the right to receive personal data that's been collected about them in a structured, commonly used and machine-readable format. Finally, the right to object at any time to processing of users' personal data. So, what's worth mentioning here is that data controllers have 30 days to respond to a data subject's request. Next, data breaches. GDPR says if there is a data breach, the processors have to inform all the affected users within 72 hours. You may have heard about Yahoo or Uber breaches that exposed data of many users, and people did not know about the fact for months or years. This cannot happen under GDPR, as the company would be facing financial penalties. As mentioned earlier, when the exposed data was pseudonymized, we are not obliged to inform the data subjects about the breach, provided of course that the data was not exposed along with the encryption keys used to encrypt the data. The last point that the GDPR brings is very interesting but also quite confusing for many companies. Data protection by design and default. It encourages the companies to think about privacy and carry out the data protection impact assessment from the very beginning when building new systems. When building a feature or piece of software, companies must assess if they really need to collect all the pieces of data they intend to, or if it is possible to anonymize or pseudonymize the data and still be able to achieve the same goal. So this one is mainly about the documentation and approach to building the software. This impacts companies quite a bit and allows them to demonstrate that they actually have done the data protection impact assessment and thought about the privacy when building the features. The approach in which companies collect the data first and figure out what to do with it later is no longer lawful under the GDPR. Importantly, a data breach doesn't have to be connected to a data hack. A data breach also means that the data is collected and processed in an unlawful way. For example, when it is shared with another company that the user hasn't consented to. And the last thing, as probably many of you are aware of, not complying with the GDPR is quite expensive. There are two tiers of fines. Tier 1 is either 10 million euros or 2% of total turnover, whichever is higher. There are a couple of things that fall under Tier 1. For example, processing of personal data when no identification is needed, not designating a DPO, or a lack of compliance with the data protection by design and default. The Tier 2 includes higher fines than Tier 1. It's either 20 million euros or 4% of the total worldwide turnover. The breaches that fall under this tier include failing to collect consent or unlawful processing of data or non-compliance with data subjects' rights. These are the maximum fines, but the regulator or enforcement body can fine the companies depending on the severity of non-compliance, as well as the reason it happened. For example, was it on purpose? Was it negligence or a one-time mistake? Also, the fine can be proportional to the company's size measured by the turnover. We recently saw an EU Data Protection Authority, in this case the French Data Protection Authority CNIL, fine Google 50 million euros because it failed to provide enough information to users about its data consent policies and didn't give them enough control over how their information is used. There is no doubt that we'll see more stories like this, as there are many AdTech and MarTech companies that aren't complying with the GDPR. This wraps up the first part of the presentation. Let me now hand it over to my colleague Michael.
Okay, thank you Michal for presenting the first half of the webinar. As Michal mentioned, my name is Michael and I'm Head of Marketing here at clearcode. So for the last half of this webinar, I'll be talking about the various legal and technical challenges that AdTech and MarTech companies face, and in particular I'll dive into the area of user consent, as this is no doubt one of the most important areas of the GDPR and one that directly impacts all AdTech and MarTech companies. Also, we'll take a brief look at the aftermath of the GDPR and the impact it's had on the online advertising and marketing industry so far. So before we talk about the legal and technical challenges, we first need to understand how the GDPR impacts the underlying models and workings of AdTech and MarTech companies. So while the AdTech and MarTech industries are becoming more and more connected and share many similarities, they are both impacted by the GDPR in slightly different ways. So MarTech vendors such as CRM systems, marketing automation platforms, analytics tools, etc. typically collect first-party data on behalf of their clients, for example websites. So if your website uses an analytics tool to collect data, then you are, in most cases, collecting first-party data, which is likely to be utilized solely by your company and typically won't be shared with other vendors or sold to data brokers. AdTech companies, on the other hand, collect third-party data via tags on websites. Also, this data is shared with multiple AdTech vendors each time an ad is displayed to a user. Just think about the typical media supply chain where an ad request is sent from a supply-side platform to ad exchanges, demand-side platforms, data management platforms, and so on. So the main point that I want to make here is that the further away a user is to a technology vendor, the harder it is for the vendor to meet certain requirements of the GDPR, such as user consent and user rights, which we'll talk about more in a moment. So now let's look at how the GDPR impacts AdTech and MarTech companies and identify the main technical and legal challenges when it comes to complying with the GDPR. First of all, AdTech and MarTech companies will need to have a straightforward process in place to receive and manage user consent decisions and user rights, for example, data access, data erasure, and so on. So if a user asks a publisher to erase their data, there needs to be a process in place that will enable AdTech and MarTech vendors to comply with their request. The consent information will likely come from a consent management platform, or CMP for short. So AdTech and MarTech companies will need to implement an easy way to receive this consent information from CMPs, store it, and access it. We'll talk more about CMPs in a moment. Also, AdTech and MarTech companies have to update their platforms to match their policies, as well as implement specific new processes and security measures with the data they collect, such as encryption. So while AdTech and MarTech companies face similar technical challenges, there are a couple more challenges that are specific to AdTech vendors. So ever since the introduction of real-time bidding between the mid to late 2000s, AdTech companies have been collecting and utilizing huge amounts of third-party behavioral data to display ads to users on an individual level. But the new rules regarding user consent in the GDPR have reduced the availability of this type of data. As a result, AdTech companies face the enormous challenge of continuing to provide value to their clients despite the fact that their entire business model has been severely weakened. Now, one possible solution to this is moving away from a behavioral targeting mindset towards a contextual targeting one, because if the number of available audiences drops as a result of the consent mechanisms installed on websites, then the actual behavioral targeting may no longer prove valuable, and publishers may also need to shift to a contextual targeting method, which shows advertisements based on the context of a page, such as the content, rather than data known about the user's behavior. One of the benefits of contextual targeting is that it can be done anonymously without using any type of personal data. And it's also important to note that this might not actually be such a bad thing, because this is how advertising works in the offline print world. For example, if you read a financial magazine, then you'll likely see ads promoting various financial products and services. Now let's look at some of the main legal challenges for both AdTech and MarTech companies. The first thing to note is that AdTech and MarTech companies will need to be able to prove that they've received clear and unambiguous consent from users to process their data for specific purposes, for example, to show behavioral ads. Now, this is particularly tricky for AdTech vendors that receive consent decisions from other vendors and not from publishers directly. There was a case back in November 2018 where the French Data Protection Authority, CNIL, ruled that consent collected by mobile DSP vendor Vectory was invalid because it received it on the basis of a contractual agreement with another data controller rather than explicitly from the user. AdTech and MarTech companies also have to sign a data processing agreement, or DPA, with data controllers as well as with data sub-processors. So if you host your technology on AWS or in Azure or in some other hosting provider, then those companies are classified as sub-processors. And because you keep your data on their infrastructure, you need to make sure that it's protected at all times. So you essentially need to have DPAs with your clients and with the companies that will potentially have access to the personal data that you collect on behalf of your clients. It's also important to ensure that the security measures listed in your DPA with your clients are actually implemented into your technology, such as pseudonymization and encryption. Now, another legal challenge is carrying out a Data Protection Impact Assessment, or DPIA. So a DPIA is a process that helps companies identify and minimize the data protection risks of a given project. For example, when building new features that can collect personal data, you should conduct the DPIA to identify the risk associated with that, for example, any kind of potential data leakage, and also look to implement additional measures to mitigate those risks. Now that we've looked at the main technical and legal challenges AdTech and MarTech companies face, let's now focus our attention on one of the key areas of the GDPR, user consent. Now, even though publishers and website owners are the ones responsible for collecting user consent, it's an area that directly impacts AdTech and MarTech vendors, as they are the ones receiving, storing, and accessing the user's data. So it's important to understand how this process works and how to manage it. So at the beginning of the presentation, Michal outlined the 6 lawful bases for processing personal data. Now, both AdTech and MarTech vendors will need to identify which legal basis for data processing is applicable to a given situation. For example, if it's to show advertisements or personalize the content on a web page based on the user's data, then they'll need to obtain user consent for the purpose of their technology. The reason why we're focusing on user consent is because it's the lawful basis that is applicable to almost all advertising and marketing activities. Alright, so what does the GDPR say about user consent? So the first thing is that consent will not be valid if the data subject has no genuine and free choice or is unable to refuse or withdraw consent without demerit. So you may have seen already in the media that companies like Facebook and other websites, such as the one given here, are already violating this point about user consent, as they deny users access to their service or website unless the user consent to their data collection activities. The GDPR also says that you can't have one box that covers all data processing activities. You must list all the purposes, so whether that be for analytics, remarketing, advertising, A/B testing and personalization, you must obtain consent from the user for each one. Also, the nature of the processing processing should be explained in an easily accessible form using clear and plain language, so no legal jargon or ambiguous terms. Silence, inactivity, or failure to opt out do not constitute valid consent, so the user really has to explicitly opt in for it to be lawful consent. And there are many examples out there where publishers are adopting an assumed consent strategy, whereby they assume that a user has provided consent if they ignore the consent form and continue browsing the website. If consent is given in the context of a written declaration which also concerns other matters, such as your privacy policy, then the request for consent must be presented in a manner which is clearly distinguishable from those other topics. Where any processing activity is performed on the basis of consent, the data controller must be able to demonstrate that it has obtained valid consent from the data subjects. This point goes hand in hand with the one about obtaining proper consent in the first place, because it's not only vital to collect consent for specific data processing purposes, you must also be able to prove it. And I'll explain more about how companies can manage this process in a minute with consent management platforms. Lastly, data subjects must be informed of the right to withdraw consent prior to giving consent, and it must be as easy to withdraw consent as it is to give it. Okay, so now that we've had a look at the rules behind user consent, let's now take a look at an example of a user consent form. When a user accesses a website for the first time and you want to collect their data, you have to ask for consent. It doesn't have to be on the first page view, but it usually is so that you can start collecting analytics data from the first page view. Typically the way it works is you display some sort of consent window or consent bar to the user where they can express their choices regarding the data collection and processing purposes you want to conduct. So with this particular user consent form, there's a clear and ambiguous message explaining the purpose of the data collection. There are settings that require users to opt in, and of course the user is opted out by default. There's a link to the tool that allows the user to manage their consent decisions and exercise their various rights. And there's also a choice to agree or disagree to their data being collected. Now, when it comes to displaying a user consent form and managing user consent, the easiest way to do it is with a consent management platform, CMP, as I mentioned before. Now, of course, there are many ways in which a consent manager can work from a technical point of view, but we're going to look at the basic flow of that now. The whole process starts when a data subject, in this case a website visitor, accesses a website. The website renders in the data subject's browser, and they are shown a consent form asking whether the website can collect and process their data for a specific purpose, for example personalization and ad retargeting. Now, there are three possible outcomes of this. The first one is that the data subject rejects the publisher's request to process their data, in which the data controller, in this case the website, can take no further action towards collecting their data. However, the data subject's consent status is recorded in the consent manager so that we don't have to keep asking for it on every page view, and also to show proof of the data subject's consent decision. The second possible outcome is that the data subject accepts the data processing activities, in which case the website records the data subject's consent status and then fires the respective tags based on the purposes the user consented to, and then the data is passed on to the relevant data processors, for example AdTech and MarTech platforms. Now, it's quite possible that the website has multiple marketing technology vendors that will be processing data on behalf of the website for each given purpose. The third possible scenario is when the user doesn't specify their consent decisions. For example, if they close the form or if they click outside the form and continue browsing the website. In this situation, the website cannot process the user's data, but they can display a non-intrusive sticky bar that prompts the user to provide consent during their current and subsequent visits. So when it comes to consent management platforms, there are several companies on the market. One of them is Piwik Pro, which is the company founded by Clearcode, but there are also other alternatives such as Trusty and Data Streams. Each of them will handle the process of collecting, storing and managing user consent decisions and user rights differently. So if you are considering using a CMP, or if you're in the market for one, then it is worth asking these companies how their technology works to ensure it meets your requirements. When it comes to the AdTech world, there are a couple of tools available on the market to help publishers comply with the GDPR and manage the user consent process with AdTech vendors. One of these is the IAB's GDPR Transparency and Consent Framework, which is intended to support publishers technology vendors, and advertisers in meeting the transparency and user consent requirements of the GDPR. So the IAB's framework standardizes the process of getting internet users' consent for data processing and relays its information further down the advertising supply chain. The framework also includes a global vendor list, which works as a registry of data controllers participating in the framework. You can think of it as like a white list of vendors through which the consent can be requested by first parties, obviously those being publishers who directly interact with users. The IAB's consent framework can also be integrated directly with a publisher's existing CMP or with their content management system. Now, there's already been some controversy surrounding the IAB's consent framework, particularly with the case I mentioned earlier involving the mobile DSP vendor Vectory and the French DPA CNIL. The issue has to do with how user consent streams, basically information about a user's consent decision, are passed from one AdTech company to another. Because the IAB's solution is simply a framework, it's actually up to the individual AdTech vendors to ensure they are receiving and handling user consent information in accordance to the rules outlined in the GDPR. Alright, so now that we've seen how user consent mechanisms should work, let's look at the challenges AdTech companies face with handling user consent decisions. So to highlight the challenges for AdTech companies, let's look at how AdTech and MarTech companies handle user consent. So when a user visits a website that uses MarTech platforms such as analytics software, A/B testing tools, etc., the website asks the user to consent to the various data processing purposes and then fires those tags belonging to the MarTech platforms based on the consent and subsequently collects personal data about the user. For publishers using MarTech platforms, this process of managing user consent and user rights is a lot easier because, as I mentioned on one of my previous slides, they are not that far removed from the user. For AdTech companies, on the other hand, these processes are a bit trickier because if the publisher receives a data subject request, for example requesting to delete their data, then they will have to ask all the AdTech vendors that have collected data about that user to delete it, which could be several dozen or even hundreds. This point is a huge issue for online advertising companies due to the amount of data that's leaked during real-time bidding and programmatic media buys. So to explore that issue in more detail, let's take a look at how data is shared, or leaked rather, during a typical RTB media transaction. As we can see in the diagram, once an ad request is sent from the browser, there may be a header bidding script that passes the ad request to several SSPs and ad exchanges, which then send the bid request to multiple demand-side platforms. Then, when a DSP wins the auction, other platforms such as the advertiser's ad server or ad verification vendor would collect data about the user as well. There would likely be other data sharing processes happening during this transaction, such as cookie syncing between DSPs and DMPs. So as you can see, there are many companies that receive personal data during RTB and programmatic media buys, meaning the publisher would have to obtain user consent on behalf of each of those companies. One possible solution to prevent data leakage would be to encrypt or even strip some of the personal data from the ad request so that the DSPs and SSPs don't receive any personal data. However, this would mean that we can't use behavioral targeting and retargeting, which have been the backbone of the online advertising industry for at least the past decade. So continuing on with the data leakage topic, here is a visual representation of what some popular sites look like. As we can see, the popular celebrity news and gossip site, TMZ, contains dozens of third-party tags. The diagram illustrates how requests are passed around from one vendor to another. Now, if TMZ were to implement a consent management platform and collect consent from users to collect their data, then they'd have to gather consent on behalf of all these vendors, as well as pass on the results of that decision to all those vendors as well. Alright, so if a publisher wanted to implement the proper user consent mechanism, they would have to create a user consent form that included all of the AdTech vendors involved in the collection and processing of personal data, which in today's online advertising world would probably look something similar to the example we have on the screen. The situation is troublesome, however, for AdTech companies for a few reasons. Firstly, as I mentioned before, AdTech companies don't have a direct or first-party relationship with users, meaning they are less likely to give consent to companies that they don't know or trust. For example, users would be more likely to give consent to Amazon or Netflix to personalize their experience, rather than to an AdTech company like OpenX, for example. Secondly, users are simply not going to waste time opting in to all of these unknown third-party ad tech companies. Lastly, there is little benefit for users to share their data with advertisers. We all know about the rise of ad blockers, the numerous privacy concerns that have made news headlines in the past, and the annoyance of certain types of ads. Online users nowadays are a lot more aware of how advertising companies collect and use their personal data, so they're going to be less inclined to share it with them. So what does all this mean for AdTech and MarTech? So privacy and data protection is definitely going to play a big role in the digital advertising and marketing industries, and we've already seen that a number of other countries are looking at strengthening their data protection and privacy laws, such as the California Consumer Privacy Act, which will go into force in 2020, as well as other initiatives in countries like Brazil and India. So complying with the GDPR means making changes to key areas of online advertising and marketing, which will impact how companies operate in the future. We are already seeing a rise in permission-based advertising and marketing, meaning users are in control of their website experience. We are also seeing less reliance on third-party data and a bigger focus on first-party data, simply because it's much harder now to obtain and store third-party data than it was in the past. Also, there's more power for publishers, those being websites, apps and brands, as they will be the gatekeepers of consent as well as the gatekeepers for loading ad tech vendors onto their website. There's little doubt that the AdTech and MarTech companies of the future will need to adapt and become more privacy focused in order to survive. But apart from the fines for non-compliance that Michal spoke about earlier, vendors may also find that their revenue will suffer as both clients and consumers may decide to only work with and support companies that take privacy seriously. We may even see GDPR compliance used as a unique selling point. The GDPR may turn out to be the catalyst for innovation to create new technology or to adapt existing technology to become more privacy conscious. Lastly, there will also be a bigger focus on advertising that doesn't use personal data, as I mentioned before, contextual targeting. For ad tech companies in particular, there is an opportunity to incorporate contextual targeting capabilities into their existing platforms to offer their clients the possibility to run advertising campaigns that don't rely on personal data, or to use contextual targeting as a backup in the event a user doesn't provide consent to behavioral targeting. Alright, so before we wrap up this presentation, I just wanted to highlight some of the main stories and topics that have emerged since the GDPR came into force back in May of 2018. So as I mentioned earlier, contextual targeting is likely to increase in popularity among both publishers and advertisers. And we saw recently a news story about how the New York Times initially stopped running ads on the European version of their site, but then switched to showing contextual ads and didn't notice a drop in ad revenue. Also, within days of the GDPR coming into force, we saw a number of US-based news websites have a sort of knee-jerk reaction and deny access to users with a European IP address as a way to avoid collecting personal data from EU citizens and residents. Lastly, Google was recently fined 50 million euros by the French DPA CNIL because it failed to provide enough information to users about its data consent policies and didn't give them enough control over how their information is used. While many companies are still operating as business as usual, the fact that certain data protection authorities have already started investigations signals that we'll likely see more of these stories appear in the coming months and years. So that wraps up our presentation for today. We'd like to thank you for your time and hope that you were able to gain a greater understanding of the impact the GDPR has on the AdTech and MarTech industries. If you have any questions regarding anything that we've covered in today's presentation, there is a contact form located on this page where you can send us your questions for us to answer. Also, if you are facing any problems with making your platforms GDPR compliant, or if you want to learn more about building privacy-related tools such as consent management platforms, then you can contact us via one of the channels listed on the screen. So thank you again, and bye-bye for now.